button right now. Amazing. Well, welcome to everybody. It's so wonderful to see you all today. I'm very excited that you all could join us on Zoom. My name is Ian Rosenthal. I'm the housing justice organizer over at Jewish Community Action. My pronouns are they, them, theirs, or he, him if you need. And I would like to welcome you to Give Tenants More Time Getting Pre-Eviction Notice Policies Passed. So this event was co-created by the Suburban Hennepin Housing Coalition, which is a collection of housing teams in the suburbs pushing for tenants' rights, affordable housing, and progressive housing policy. And it was co-created alongside Homeline, a nonprofit that provides free legal, organizing, educational, and advocacy services so tenants throughout Minnesota can solve their own rental housing problems. Homeline is also kind of deeply embedded in the policy arena, pushing both for local and state level policy. And so today, what we're going to be doing is learning about pre-eviction notice policies, how they may benefit tenants, and then how current examples of this type of policy are sort of playing out on the ground. But before we get started, I will kind of give the shape of our program today, give you a rundown of the agenda. So first, we're going to start kind of by grounding ourselves with some numbers to understand the eviction crisis broadly in Minnesota. We are going to take a look at both the state level and a couple of example cities, kind of to drill down into the numbers. And then we're going to transition into learning what a pre-eviction notice policy is and how it can help. After that, we are going to have a 20-minute session for question and answer, which I'm really excited about. And then we will move from Q&A into a section we're calling Notes from the Ground. So that's going to be a section kind of to juxtapose two current policies and how they're playing out in the respective cities that passed them. Excited for that as well. We have some great insight from folks doing great eviction prevention work in St. Louis Park. Then we're going to move on to the local versus the state level for this type of policy. So we're going to learn about the landscape at the state level and the possibility of passing it on the state level. And then we're also going to go over kind of why it's still worth it to push for it on a local level, in addition to supporting state level pre-eviction notice policy. Well, depending on time, we might have kind of time for a few final questions, and then we'll kind of close out together. But without further ado, I would like to invite Ozzy from Homeline to come off mute and kind of kick us off for learning about the eviction crisis that's currently unfolding in our state.
Sure thing. Thanks, Ian, for that great introduction, and great to see all of you. Some very familiar names and faces. I guess not really faces, because I haven't seen a lot of y'all. But yeah, voices for sure, and through email on the names. But yeah, here we go. As Ian said, I will be presenting just general numbers statewide, and then more closely focused on the metro, specifically Richfield, Plymouth, and blanking on the other one, but there's a third one over here. So I'll just kind of get into it. This is sort of the schedule that I'm going through for my little presentation, starting with data collection. I'll go over my process of how I do that very generally without getting too much into it. And then I'll go over state data, what it's looking like at the state level, and any patterns I'm sort of recognizing, an overview into Richfield, Minnetonka, and Plymouth. So there's that third one I was looking for. Yeah, cool. So I'll just get into it. So yeah, data collection process, very generally, I am accessing this information via MCRO, Minnesota Public Access, and Minnesota Government Access, which isn't so much publicly accessible, but it basically contains any other information that's found in MCRO. And the URLs are down here, and I can send them over email if anybody needs them, just over email, I guess, through text, because I know it can be kind of a pain to try to get the text down here from this long string of text there. But essentially, with how I'm collecting this data, I'm able to separate out specific cases from each other. So if I'm looking at like a geographic area, a zip code, a city, I can do that. And I'm also able to distinguish from non-residential cases. So in the court system, it's all lumped together, like commercial evictions and then like foreclosures and things like that. So I do sift those out, and I will be only presenting residential cases in this presentation. So just tenants, right? And so after I collect this data, I do hand hand stuff these letters to send out to these tenants, and particularly in Hennepin and Ramsey. Unfortunately, this letter that we send on Homeline at Homeline, it is their first sort of notice that they are being evicted, that there is an eviction filed against them. This is just because there's just so many cases coming out. There's a large delay. I know Hennepin is kind of trying to do something differently. And they're getting filings issued 3 weeks after the eviction is filed. But before that, it was really terrible. It was like 1 month out. So they are kind of getting better at that. But yeah, this is their first sort of notice that they are being evicted, unfortunately. And if you're more curious about how I'm collecting this data, I did do a webinar, one of Homeline's webinars here, where I go into that more. Again, this is just a line of string of characters and things here. But if you go on the Homeline website and you look up on the search bar for Oscar, it's that second link. And I really do delve deeper into the data collection process if you're curious about that. Okay. So statewide level here. Let's see here. So for 2022, from the start of the year till the end, we're basically looking at 22,238 total residential cases that were filed under that year. So these aren't total evictions per se, but they are total filings, right? So a lot of things can happen after they're filed. And these graphs, or I should explain these graphs. So these in the blue cyan color up here on the top right, these kind of go together. These are why these cases were filed. This is the data table here, this lower blue rectangle here. This pie chart is that same data, just in pie form. And down here in the red rectangles here, this is total cases by month here on the right. So here we'll talk a little bit more about this, but here you're able to see that January 2022, that start of the year, was very low in filings compared to the rest of the months. And I think that mostly has to do with the renter protection still being active there, the COVID renter protections. And this bar graph here on the sort of in the center, this is total weekly filings. So I think it's from Sunday to Saturday. Basically what that number aggregates to. And we can see some interesting patterns here too that I'll talk about in a little bit. But essentially, 53% of all cases statewide were filed due to non-payment alone. So this is just classic, can't make the rent, so they're being evicted. And there's a lot of things that arise from not being able to pay your rent. Usually it's hand in hand with not being able to pay utilities, and things like that. And sometimes it's lumped with like other miscellaneous charges. I know like there's like administrative fees and all these like weird tacky things that landlords like to just put on there. But I do sift through those. I do count like those administrative fees as just non-payment, because that's where that charge arose from, right? But yeah, almost half of the little bit past half of all cases statewide were filed due to non-payment alone. 34% of cases were non-payment with another reason. So the other reason that's usually sort of coupled with non-payment is non-payment of utilities. So that's what this 34% includes. And then some other, the other common one I see is an unauthorized like pet or occupant. So sometimes they'll have like a relative staying over and the landlord doesn't like that type of thing. So that's what the second bullet point sort of points out in this top right section here with case reasons. 504B.171, that's like illegal activities that's like occurring in the premises, and the landlord is obviously not allowed to have that sort of thing happening there. That's what that means. So moving on here, the peak month of how many like filings there were in a specific month was June. So June we saw probably the highest filing per month here at 2,574. And then things kind of went down after that. Generally from January till about July, things kept creeping up. And then we hit that peak in June, I should say, my bad, June. And then after June, things kind of went down just a little bit. And then they plateaued the rest of the year at around 2,000. In October or November, I should say, we did kind of dip down. We did see a dip down. And I do think that was due because there were like a little bit more holiday weekends that weekend. I want to say there was like the voting thing, and then there was the Turkey Day too. But yeah, generally after that peak in June of 2,574, we did sort of go down and plateaued at 2,000. And then dividing this total number, grand total 22,238 divided by 365, we're at about 60 filings per day statewide. Let's see. Yep. So moving on, some more data statewide. I don't know if there's like a way to move this thing. This thing always gets in the way. All right. So 2023 so far. Down here is the daily totals from December to February. So that's just last month. Or yeah, the start of this month. But yeah, the start of 2023 January. I think I got this title wrong over here. And I did just sort of place the total for January down here. So this is January 2023. January 2023, we ended at 2,255 total filings for that month. That's up 14% from December of last year, and up 36% from November, which is the last month that wasn't at 2,000, right? Just look by looking at this, and then things went back up, unfortunately. And comparing January 2022 to January of this year, yeah, right, that's a 130% increase. And obviously, like I mentioned before, this is due to the COVID renter protections going away, but that sort of puts it in perspective, right? Like it's sort of yeah, they really let the floodgates sort of implode on themselves, unfortunately. And we're seeing this in the numbers, right? Let's see. Yep, don't really touch that. December, yeah, December. Okay, so I should also mention that evictions, daily eviction numbers in like a span of a month, it's sort of like a bell curve in the sense that at the start of the month, the 1st till about the 9th, we see like the lower eviction filing numbers per day. And then as we progress to like the mid-month, sort of around that range, around the 15th or the 12th, we do see that's when we see a surge in eviction filings, and then they come back down for the last few days of the month. But unfortunately, the surge for December was like odd in the sense that it lasted way past around the 15th or so, when we expect to see that mid-month surge, and it lasted up until the 25th. Which is over here. If you see my mouse cursor, that day on the 25th of last month, we were at 141 total filings for the 25th, and then it significantly fell down almost in half, right? For the 26th. And then it climbed back up to 100, sort of plateaued around 100. So yeah, December was a weird month in that sense, that the surge lasted a little bit longer. And then we ended up with that 2,255 number for January 2023, which is very high, unfortunately. And I think this concludes the statewide data. I'll be moving into more metro, Richfield, Minnetonka, and Plymouth eviction data. And again, this is residential data only, so tenant cases, no businesses or anything like that. So Richfield, very similar pattern of graphs here. Over here on the right, we have a pie chart that has all the reasons that the or the cases were filed. Except this time they span from January 2022 up until January 2023. So there's that 13th month that this is accounting for here. Yeah, 293 total filings in that span of 13 months. About 3.5% of all Hennepin cases. So in Hennepin, between those 13 months, there were 8,026 cases. So they made up for 3.5% of all the cases. Yeah, and I guess the other notable thing here is that October had a high number of filings. If you see all the other months, it's not really, anything to sort of point out up until you get to October. And if I'm remembering correctly, October was so high, and so was January, right? January 2023, last month, was also high. It was just about the same as October. And a lot of those are being filed by this concierge apartments place. So something's going on over there. But the rest of the months, they weren't too bad, right? November was pretty chill. And November, again, was that month where we dipped down below 2,000 cases statewide. So, we would expect to see a lower filing rate over there. Yeah, and over here, we see the case reasons. About 47% were due to non-payment with another reason. So again, that's usually coupled with non-payment of utilities. 42% of all these cases out of the 293 were filed just due to non-payment alone. Yeah, this concludes Richfield. So moving on to Minnetonka. Same deal again, pie chart sort of breaks down the case reasons and why they were filed. We see a little bit different pattern here for monthly totals in Minnetonka. This one actually has a more distinguished shape in that it's kind of like it goes up in April, comes down a little bit, and then it sort of peaks in June. That infamous June number that I was just talking about, where it was just crazy high and then goes back down, climbs up a little bit, and then goes down. So really the notable sort of figure that we're looking at here is 26 total filings for June. That made up 189 total filings for Minnetonka. So about 2.3% of all Hennepin cases, slightly smaller than Richfield just a little bit ago. But yeah, the main peak months for Minnetonka, it looked like it was April and June. And this is like I think they call it like moving season and stuff. So it's sort of expected that more things are happening around the summertime. And what's interesting here is that essentially non-payment and then non-payment with other reasons made up equally 46% respectively out of the pie chart. So this is kind of particular to this um county because generally like a non-payment alone makes up like a large percentage of it, a much larger chunk out of the pie than all the other reasons. And here it's pretty much equal with non-payment with other reasons. Yep, so moving on, Plymouth, 230 total filings within that 13-month span, about 2.8% of all Hennepin cases. Peak months were June and July. These are really particular here because you see everyone else is sort of every other month is sort of down under the 20s really. And then June and July they just shoot up. December is sort of also kind of up there. And I did try to find who's like filing these, but unfortunately it is sort of more difficult to pinpoint these down because a lot of them are coming from a particular like street, but then a lot of people, or not a lot of people, there's just different management groups and management companies that own those different buildings. And I should also say that we don't collect landlord data, so we are only collecting tenant information. But when a particular case is filed, we're not noting it. I just pointed out concierge earlier because I know I'm very familiar with that area, that building, and it was really easy to sort of pinpoint which cases it was. But just generally, we aren't collecting landlord data. Let's see here. And the percentage for the pie charts here are a little bit more typical for what we would see statewide, and then more generally, 55% were due. Or actually, no, I take that back. It's the opposite. It's sort of the opposite of what we would see typically statewide and generally with case eviction data. So 55% were filed due to non-payment with another reason, whereas only 38% of all cases were just non-payment alone. So and this Plymouth is sort of the odd one out in the sense that much less cases involve just non-payment alone, non-payment of rent alone. Yep, and I think that this concludes my presentation here. I will take questions if anybody has any, if anybody wants me to go back to a particular slide.
I think we can stash those questions away for our Q&A section. Thank you, Ozzy, so much for the really illuminating numbers. Sobering to see these numbers, and also important to keep in mind the human cost behind these displacement actions, right? So just moving right along in our agenda, we will scoot over to talk about what a pre-eviction notice policy is and how it can help. And I will hand it over to Mike to jump into that with us.
Thanks, Ian. Yes, and I'm sorry, I never follow Ozzy with charts and graphs because mine would always look inferior. So I just am going to talk right now. I'm going to talk about pre-eviction filing notice requirements and what they are, where they exist right now. To start, arguably, there's a little bit of debate. It's either 46 or 49 other states have some type of pre-filing eviction notice requirement. Minnesota does not. So what that means is, in all but 3 cities in Minnesota, if a landlord is waiting for rent, the rent is due on the 1st, which it almost always is for tenants. On the 2nd, the landlord has the right to go file an eviction for non-payment of rent. No requirement that the landlord warn the tenant at all that the rent is late and they're going to go file the eviction. That's the rule that we have, the general rule that we have throughout almost all of Minnesota. We have 3 cities that in the last couple of years have adopted pre-eviction filing notice ordinances. going in sequence, St. Louis Park was the first. Their ordinance had a lot of different versions before it was ultimately passed, but it requires the current version, and the one that's in law now in St. Louis Park is a 7-day requirement. So the landlord has to tell the tenant in writing, hey, this is how much money you owe. And if you don't pay, then 7 days later, I can go file an eviction. Next was Minneapolis. They came up with a 14-day ordinance. So it's very similar to St. Louis Parks, except that the landlord has to now give a 14-day warning, once again, telling the tenant about how much rent is due and the deadline to pay it. And if not, then the landlord has the right to go file the eviction after the 14 days. Last, and most recent, is Brooklyn Center. This is like a strange exercise in doubling theory. They went with 30 days. So we had 7, 14, and then 30. So I'm not sure if the next city that tries this is going to do 60 days. We'll see. But no, a 30-day requirement. So the landlord has to say, hey, here's what you owe. And then 30 days later, the landlord would have the right to file the eviction for non-payment of rent. The stats that Ozzy was just showing us on the screen aren't exactly typical. In most years, by far, the number one reason for landlords to file evictions is for non-payment of rent. If you were looking at the stats and the percentages that Ozzy had on the screen, they're skewed a little bit by last year. During the first 6 months of last year, a landlord had trouble filing an eviction for non-payment of rent. There were still some COVID protections in place that wouldn't allow landlords to file evictions in certain circumstances. So that's why we saw a massive surge in every category. It was June and July were the big leaps in numbers. And that was because all of the COVID protections were removed at that point. And then we started to return to sort of more normal approaches to evictions. Landlords file evictions for non-payment of rent in Minnesota. They have become effectively part of the collection effort that landlords either are forced to use or feel like, hey, I should use that a little bit quicker than other landlords do. I can tell you, having done this a long time, that in normal times, Ozzy mentioned a mid-month surge in evictions. That's based on history, really, and kind of what landlords have always done. A big landlord, for instance, wants to file all of their evictions on one day of the month. That way, their attorney can appear in court for all the cases on that one day of the month, so they don't have to send the attorney back again and again for multiple cases. It's just more cost effective for them. So over the years, we have looked at this carefully. The 12th, 13th, 14th, those are the most common days of the month that landlords file evictions. So they give the tenant a little bit of time, but not a lot. The pre-eviction notice is, as it's set up right now, for non-payment of rent only in St. Louis Park and Minneapolis. In Brooklyn Center, they have a breach of lease requirement that the landlord also has to give a warning to the tenant about a breach of the lease. But in Minneapolis and in St. Louis Park, it's for non-payment of rent only. Has this ordinance or have these ordinances had any impact? I look at eviction filings virtually every day that I work on our tenant hotline. We're taking about 20,000 calls a year. And absolutely, the court seems to treat this sort of like we lawyers think of as a threshold issue. What's a threshold issue? Well, you can't get to the heart of the actual court case, the non-payment of rent, for instance, unless you satisfy some basic threshold issues to start a court case. So, for instance, a landlord has to serve court papers properly. This is when the landlord actually files the court case. At least 7 days before court, the tenant is supposed to give the court papers so they can decide how to defend the case or maybe go try to get some money from an agency. And that's a threshold issue. If that service of process issue isn't satisfied to the court's satisfaction, then the case is dismissed. This is being treated sort of like a cousin to service of process as far as a legal defense goes. That if it's in a city where there's a non-payment of rent requirement, the courts seem to treat it as if this is just the rule now that everybody has to play by. There are a lot of lawyers that just represent landlords. It's pretty much what they do right now, and you'll have to trust me, business is good for them. They are doing a lot of evictions right now. They're all aware of this. They all follow these rules. The landlords that don't probably would be landlords that own 1 or 2 units, don't realize that this is a rule. It's harder to glean from the laws. You'd have to know a city rule versus knowing a state law, which are a lot easier to find. So anyhow, that is kind of the intro to the ordinances that we have on the book now versus what we have in the rest of the state, which is no warning required at all. And I think I started a little late, so I'm going to try to end quickly so we can get to the next issue.
Amazing. Thank you, Mike. Yeah, so I'll pass it over to we're gonna have a Q&A session now. So the way we're gonna do this, you can either drop a question in the chat. I see that folks have already been putting their questions in the chat and getting some answers. We'll try and get to that. We have a few canned questions that we'll kind of open up to the experts on the call right now as well. And then if you want to ask a question out loud, feel free to go to the reactions button in your Zoom window and raise your hand, and we will call on you. Yeah, let's get rolling with a question. Our first gathered question is, what can you do to improve an existing policy in your city if your city does have a pre-eviction policy already?
Well, I could jump in with this. For instance, like St. Louis Park, for instance, could make their notice period longer. I don't mean to run down what St. Louis Park did. They were first. And so it was a somewhat bold move. I think they were maybe concerned about whether that was going to be challenged legally. To my knowledge, it hasn't been. But they could change their policy to make it a longer notice policy to be in line with Minneapolis and or even Brooklyn Center.
Awesome. I'm seeing Nancy. You can absolutely come off mute if you have a question.
What's a reasonable amount of time for somebody who gets an eviction notice to find a lawyer, to get resources, and to be prepared for going to court?
This is Eric at Homeline. I'll jump in quick. So that's a good question, and I think it depends, right? And that's sort of one of the challenges with these and why there's been differing time periods for these pre-eviction notices. Again, the purpose of these notices is to try to prevent the eviction from ever happening, prevent the actual filing from ever happening. So, preferably you don't need an attorney if the eviction isn't ever filed. So really the purpose behind these is to try to get folks the information about that they're behind on rent, which they may not know. Sometimes we get calls all the time that there's disputes about or confusion about how much is owed because of partial payments or late fees or whatever, utilities, etc. So really the question really comes down to how quickly can somebody, once they realize that the landlord believes they're behind on rent and maybe they agree with it at that point, what resources do they have to go find? And that's a troubling issue and was over the past year, as I think folks maybe saw in the news in terms of how long it took the big statewide program Rent Help MN to get funding to people. And it depends on where you are in the state, a lot of different things. So, 7 days, 14 days, 30 days, that might be enough time for somebody to seek rental assistance. It may not. One thing that was part of the end of the eviction moratorium last year, that ended in June of last year, was an additional protection that prevented evictions from proceeding if tenants had a pending application for a rental assistance. And that's a separate issue, but that's sort of a little bit of kind of the underlying idea behind this, is that let's give people enough time to prevent the landlord and the tenant from having to go through that whole court process. And so that really comes down to what resources are available. And right now there's just not enough rental assistance out there. And there's a lot of pushes at the state legislature to get more. And then, the timeline you'd think that should be a simple process, getting money to a landlord and to prevent homelessness for a tenant. But as we saw last year, it can be a complicated process. It takes a bit of time. And so ultimately that's really that's really what these types of protections should have in mind is how much time is it going to take, and that's sort of an open question. And so we've always advocated for as long as possible. In the case of that, we don't have a perfect system in Minnesota for rental assistance yet, but prior to the pandemic and prior to Rent Help MN, it really is up to sort of individual counties and their processes for getting emergency rental assistance out. So I'm not sure, that probably isn't totally answering your question, but that's part of the problem.
But there's no mechanism. I mean, I remember when we were doing foreclosure counseling, and there was a way that we looked up the records to see who was going to be evicted. And we kind of went around with printed resources and just gave them to people. I mean, is there anything like that so that people can hit the ground running when they hear about the fact that they're going to be evicted?
That's great, and it follows up with another question that Tess posed, I think, in the chat of, is there any consideration of requiring that tenants be provided information about resources and supports that would be available for them in helping prevent an eviction?
Yeah, this is Eric again at Homeland. The three city ordinances that are on the books right now do require, I think, at least Minneapolis and Brooklyn Center do require that the notice provide some information about what resources are available. And then beyond that, so again, the pre-eviction notice is before a case has been filed. Let's get information to tenants, which is a good idea. And so only in those three cities does that exist. Beyond that, there's the program that Ozzy talked about that we have here at Homeline, is that when an eviction is filed, a couple things happen. One, Ozzy finds out about it and we send a letter. We send a letter to every eviction defendant in the state so that they can call and get free legal advice. And so we'll provide them advice, and then we'll also refer them to more legal support if they need it, or financial assistance or anything else that they might need. Separately, then, when an eviction is filed, the courts, each court district sends there's information in the eviction complaint and summons that tenants get, and those differ by county. But in Hennepin County, the eviction summons does have information about Homeline, about legal aid, about rental assistance programs. But of course, often that, it may be too late. I mean, at that point, the eviction is filed, right? It's on their record, and their court hearing may be as soon as within the next 2 weeks, which can be a very difficult timeline to get what they need.
A couple things about what Nancy just has asked about here. First of all, the foreclosure, if you want to compare the two, it's not the line of work I'm in, but it's 10 months to a year roughly before somebody has to leave their home for a foreclosure. It takes a long time. Societally, the way we have our system set up in this state, we basically said that tenants aren't worth the same amount of notice as a homeowner is. They don't get 10 months. They're going to get an average eviction pre-COVID, 20 to 30 days. That's how long it takes from the day the landlord files the case to the day the sheriff comes a second time and physically removes a tenant. On average, 20 to 30 days. That's what we're looking at. Not 10 months or a year like in a foreclosure. And so we're saying, hey, renters don't get as much protection. We seem to be okay with that societally, although we're talking about it right now, which is great. The other thing is these pre-eviction filing notice requirements, there is an alternative to the tenant paying or the landlord filing an eviction, which is the tenant might decide to simply leave prior to that pre-eviction filing time being up. We haven't talked about this at all because it's a really big topic, but having an eviction on your record when you're applying for other housing. In the metro area, 85–90% of landlords will turn a tenant down for a recent eviction that's been filed. It might be in the tenant's best interest to say, you know what, I think I should just go before they file, saving the landlord the money and hassle of going to file the eviction, which costs about $300, and they might hire an attorney as well. So that's one of the things that has happened. Eric was right when he said the goal of these ordinances isn't to make it harder for landlords to do evictions. It's that evictions never get filed. The tenant either pays up because they realize what's due, or maybe they go before the case is filed.
if they can find housing in 30 days.
Of course, that would be a challenge, but there are times when tenants do the cost benefit analysis. I talk to them frequently, and they decide, well, I think it's best for me to live with my mom for a month. It's going to work out. We'll put our stuff in storage and find a new place. But if we can keep the eviction off our record, it's worth it.
Yeah.
And some people decide that going to a shelter is better than having something on their record for a long period of time as well, creating homelessness. This is Michael Dahl with Homeline.
Can we name how long that is? How long does an eviction stay on our record if you get one filed against you?
So an eviction is actually on somebody's record forever, unless the court removes the filing. Practically speaking, 7 years is sort of how long they impact people based on some federal laws about credit reporting. And so 7 years is really the part we care about. In Minneapolis, there's a specific ordinance that limits the look back to 3 years, but it's not a fully enforceable ordinance. Again, it's almost every part of the work that we do. One of the things in the back of our mind when we're advising a tenant on the tenant hotline is, you know, what if an eviction is filed and what impact is it going to have on this client? And so it's a huge shadow to all of landlord-tenant relations in Minnesota.
Jump in with another one of our gathered questions here. How does Minnesota compare to other states? Are there other states with pre-eviction notice policies to model from?
Yeah, again, as I mentioned earlier, it's either 1 or 4 states that don't have any kind of pre-eviction. There's an honest debate between lawyers about which ones count, and unless you practice in those states, it's really hard to answer. But almost every other state has something. And I can say that Minnesota is among the fastest day of filing to day of sheriff removing somebody processes in the United States. Certainly nothing to be proud of. And yeah, the pre-eviction ordinances that have been drafted, the one at the state legislature that's being drafted. I'm a lawyer, and I can tell you when legislation is considered by a legislator, the first thing they try to do, if they can, is they try to plagiarize. They try to find somebody else that's already drafted something that's working. And if so, they incorporate what they like about that. Maybe they leave out what they don't like, and maybe they meld it with other states. So yes, it's something that's been modeled after other parts of the country.
We've got a question in the chat that maybe we don't have. Let's see, if an eviction is filed, but then the landlord loses the case, i.e. they failed to give notice in one of those cities, does the filing still go on the tenant's record?
Short answer is yes. A tenant's record is started with an eviction the day the landlord files the case. It's immediately on a tenant's record right now. There's legislation to change that being proposed at the state level, but it's not done yet, and who knows. So yeah, the minute the case is filed, it's a public record that anybody can see. You don't need to be a lawyer or a screening company, have some super secret password or pay a fee. Anybody can see this information. And so unless the tenant gets that expunged or erased from their court record, it's going to be a brand new hurdle, a really high hurdle to finding new housing.
This is Eric again. I want to add something to that, which I think is pretty remarkable, is that our program where Ozzy's sending out these letters, in some cases, in many cases, tenants get that letter before they get eviction summons. And we have instances it seems to be happening more often where tenants, where the landlord decided to file the eviction, but then the tenant ends up paying. They just were late by a few days, right? And so then the landlord goes and tells the court, oh, you can dismiss that case, and the court dismisses it, but it's still a public record. And then the tenant ends up not getting the court summons or anything. And the only way they find out about the eviction is our letter. They maybe wouldn't have found out about it until they were moving out and their prospective landlord sees it on a screening report. So there's just really lot of bad policies around how this works.
I don't know if we have an answer to this one, but how many of these evictions are settled with mediation?
That's really hard to answer, and not something we track. We have done some studies historically where we've looked at that sort of thing. Most mediations, again, almost every non-payment or almost every eviction is non-payment of rent. And so a mediation would typically be some sort of payment plan between the landlord and the tenant, where the tenant would agree to pay a certain amount, maybe the day of court, and then they would pay the rest on a biweekly basis or something until they get caught up. And other times we see mediation agreements where the tenant has simply agreed to move out 7 days later or 14 days later or something like that. So it's technically a mediated agreement, but it's not really a settlement. Not really, at least not doing much for the tenant. They could have gotten the 7 days from the judge simply by asking for it. So many of them are mediated, but some of the times the tenant lives up to the payment agreement. Some of the times they don't. Short answer.
Thanks. Do landlords file evictions online, or if not, how is it filed?
I think they can file them online everywhere in the state now. That's not what everybody does. Sometimes they're filed in person. It's going to be very county or district specific.
Can a landlord force tenants to pay in a certain way, specifically online via Rent Cafe or something like that?
And I apologize for the abruptness of these answers and me just sort of jumping in, but I'm trying to keep us moving along. Yes, a landlord can require a specific form of rent payment if they like. It's got to be in the lease. They can't change the lease midway through the contract. There are some states that are starting to ban non-cash payment requirements. It's not something that's really been seriously proposed in Minnesota as of yet. But yeah, a landlord can say you have to pay through this mechanism.
Mm-hmm. Thank you. And this last question, we do have a bill number for the pre-eviction notice, and you can access that. We can send that out to you as well, so you can see that sort of language later. Let me see. I'm trying to read this latest question. So if an eviction is filed and 2 hours later dismissed, I'm guessing that the tenant would still need to file expungement, and the landlord cannot just ask to remove it from somebody.
Under the current law, that's right. A landlord, the only party in the world that is allowed to ask for the expungement in that situation would be the tenant under the statute that we have. And probably the tenant would have to pay $300 to file a motion for an expungement unless their income is low enough to qualify for a fee waiver. And you might think, well, a lot of tenants would qualify. It takes a pretty low income level to qualify for a fee waiver. If you're working full-time, kind of a minimum wage job, it's a decent chance you wouldn't qualify for a fee waiver. So $300 to file that expungement motion.
And can it be, settlements, can expungements be a part of that settlement process?
Yeah, an expungement can be part of a settlement process. The court has discretion to say yes or no to it. They are increasingly being approved by courts and added to settlement agreements. One of the reasons why Ozzy's numbers, if you looked at something like a Star Tribune article that came out a couple of weeks ago saying the number of evictions that were filed last year, we know that there were more evictions filed last year than what, for instance, the Star Tribune reported. Just a lot of them have been expunged in the last year.
This is a good posing question. So what happens if as a mirror question to this, so what happens if landlords are late in providing CRPs to tenants?
Slightly off topic, but I get the point of that this is sort of related. So a CRP is a credit for rent paid. A landlord is supposed to give this information so a tenant can do their taxes, and it's due by January 31 for all rent paid the calendar year prior. Just like a W-2 from an employer is due to that employee by the end of January, so you can go do your taxes and hopefully get a tax refund if you're waiting for one. There is a penalty in place if a landlord doesn't provide that to the tenant of $100. The tenant doesn't get the money. I don't know how often it's ever sought by the Department of Revenue. I think they only do it if a landlord is really, being an obstacle going forward. So it's not something that landlords get the wrath of the state much. There is a way for a tenant to bypass the tenant in doing the CRP, but I think this Department of Revenue encourages everybody to wait until March 15th, even though there's a January 31 deadline officially in place.
And then one of our gathered questions I would really like to highlight here, because I think it's a good one. So housing court is administered by county. And while the existing policies are at the city level, how is a pre-eviction notice recorded and enforced, and by what jurisdiction, county versus city?
I can jump in quick. So yeah, there's courts in each county. It's the Minnesota Judicial Branch that oversees evictions. Cities, a lot of cities have rental licensing and inspections, and so that's most of the cities in the metro. And so cities can enact additional protections and regulation of businesses in their city, and rental housing is a business. The way that most of these city ordinances work is they require that the landlord provide these notices prior to an eviction as a condition for having a rental license. If you're going to run a business in our city, we want you to run it this way, and this is one of the regulations that we think is a good business practice in our city. And so there might be some enforcement on a local level, in that if a landlord's not doing it, then the city might say, hey, you're not going to have a rental license anymore if you're not following this. But ultimately, it does end up in the courts, right? If a landlord, on an individual by individual basis, if a landlord doesn't do it properly, then, and they might still try to file the eviction, the landlord or the tenant would have a defense to that eviction by pointing to the city ordinance and saying, hey, they didn't follow this. Tenants do this already, and we help, and legal aid helps tenants in court do this already for a variety of other things. Like in some cities where a rental license is required to rent, there are definitely landlords who do not follow that rule, and they might not be able to evict, or they might not be able to enforce some provisions of their lease or rent, collect rent or something if they don't have that rental license. But ultimately, that most of that enforcement and is in the courts. I will just note another, and I'll put the link in the chat. We had last year, we also had a webinar where a housing court referee in Hennepin County came on and talked about how the Hennepin County courts are they talked about a lot, but they specifically talked about the new ordinances in Brooklyn, or sorry, at that time I think it was just St. Louis Park and Minneapolis, and how in Hennepin County the housing court was handling the new ordinances. And I'll put that link in the chat.
Awesome. Yeah, I think with that we can kind of close out that Q&A session. Depending on how we do on time for closing out the rest of the program, we might have the opportunity to ask some more questions later. But I will pass it over to Reagan right now to talk about and introduce this section on how these policies are playing out on the ground near us.
So as we've kind of discussed, and as it's kind of been hinted at, not all of these policies have been created equally. The 3 cities that have them have had different processes, different requirements, and different expectations of what this will look like. So we're really lucky to have one of the representatives from the St. Louis Park housing team with us today to talk a little bit about her experiences on the ground, how this has played out, how she's seen the pre-eviction policy work in St. Louis Park. We're also going to give you a little bit of information on the policy in Brooklyn Center, kind of comparing the shortest term limit that we have with the longest term limit. Unfortunately, we don't have anybody from Brooklyn who is involved in getting the policy passed in Brooklyn Center with us today, but Homeland did do another webinar with Fatima, the housing organizer over at ACER, who was pretty critical in helping get that passed over in Brooklyn Center. So I'm going to move this over to Marilyn and give her the floor.
Okay, so hi, I'm Marilyn Klug, a member of the St. Louis. Okay, can you hear me? Okay. Okay, I'll start. I'm Marilyn Klug, a member of the St. Louis Park Community Housing Team, and I'm an advocate for providing tenants with pre-eviction notices. While I'm an advocate for pre-eviction notices, St. Louis Park's ordinance needs to be stronger as a way to keep tenants in their homes and stay out of the court system. St. Louis Park's notice can be strengthened by uniform notice language, how landlords notify tenants about it, and a longer notice period. I'm grateful St. Louis Park stepped up to be the first city in Minnesota with a pre-eviction ordinance. Our team's focus since October 2020 is eviction prevention by connecting with tenants who are facing a possible eviction by providing them with support and information that will assist them in advocating for themselves for a favorable outcome in a complex rental housing system. Our eviction prevention work entails sending them a packet of information and meeting them at their homes. Our packet includes important actions to take, like obtaining legal advice and a representation, their eviction complaint, a resource list, and other documents on their public record that might help. We give them the eviction complaint because landlords are not required to give the document to their tenants. Because our first contact with tenants is when an eviction complaint has already been filed, the issue of receiving a pre-eviction notice did not come up. When it was brought up about the notice, some tenants seemed not to know what we were talking about. We do access the tenant's public record to gather information needed to prepare our packets and gain some understanding about the situation. We discovered some pre-eviction notices are included in the tenant's eviction complaint to the Hennepin Housing Court. But it seems a small number of landlords are submitting it to the court. I noted that these notices presented varying information and there was inconsistency and or inaccurate information, and following our examples from 4 notices. 1, none of the notices included the following words: pre-eviction notice. The St. Louis Park ordinance does not use these words either. The ordinance states requiring 7-day written notice to tenant prior to owner initiating eviction proceedings. Only one notice header stated the following: 7-day notice of intent to file an eviction. The other notice headers were as follows: 1, eviction notice, notice to pay rent or quit. 2, notice of outstanding balance and demand for payment. 3, eviction notice. None of the notices prove the tenants received it. A tenant did share that they did not receive the pre-eviction notice, but the landlord's attorney presented the notice at their hearing. The tenant's public record did not include their pre-eviction notice. Did the notice get lost in the mail? Did the tenant misplace it? Or was it sent? One notice explained if you apply for rental assistance, let the manager know, and then the notice stated, otherwise, I have been authorized to commence an eviction action against you in Hennepin County Housing Court to have you forcibly removed by the Hennepin County Sheriff. That is an inaccurate statement about the formal eviction process. Even if one tenant received this notice, one is too many. Some of the notices need to be read carefully to understand what the notice was about. Based on interactions with tenants, a 7-day written pre-eviction notice is not long enough to obtain funds to pay past due rent. From what I have learned primarily by talking with tenants, it is very difficult to obtain rental assistance in 7 days. Getting rental assistance is not a short process, and places who provide rental assistance have different eligibility guidelines, application processes, and there is delay in funding sources responding to tenant calls. Sometimes to obtain rental assistance from one source, the tenant needs to be denied by another source. It does change who has rental assistance funds at any time. Sometimes a tenant is approved to get rental assistance, but it will take a while before they actually get the funds. A strong pre-eviction written notice needs to be at least 14 days. This will give landlords and tenants time to work out agreements and or access funds to avoid navigating the overwhelming housing court system they would face. By getting a glimpse of how St. Louis Park pre-eviction notice ordinance is working, these are some on what needs to be included in a pre-eviction notice, as they are as follows. Require landlords to use a template with straightforward and uniform language to assure all rental properties are giving all tenants the same information about it. Minneapolis has a template for their pre-eviction notice, but I do not know if landlords are mandated to use it. Require notices to be submitted to the court when they file an eviction complaint. Require a mechanism to show proof tenants receive the notice. Require at least 14-day pre-eviction notice. St. Louis Park is one of the few cities in Minnesota with pre-eviction notices. Tenants, landlords, experts, government officials can learn from these existing laws for creating pre-eviction notices in other cities at the state level and to prove on the ones in existence. New rental laws need to be focused on simplicity, clarity, and uniformity to be effective. Strong pre-eviction notices are a step forward to get tenants and landlords on the even playing field. Let's do the work to get pre-eviction notice laws at the state and at city levels that will serve tenants and to be one of the many tools needed to confront our housing crisis. Thank you.
Awesome. Thank you so much, Marilyn. And yeah, for other cities that are considering, or other housing teams that are considering pushing for something like this, it is, as Marilyn said, very valuable to hear some of these lessons and hear some of the ways that maybe the pre-eviction policy in St. Louis Park hasn't been assisting tenants in the way that it originally was intended to. I'm going to put in the link right away, or in the chat right now. This is the webinar that explains the policy and how it works in Brooklyn Center. So Brooklyn Center is also a little bit different in that it requires not just a pre-eviction policy, like a pre-eviction notice, but it also requires that the landlord choose from a selected list. This was decided within the ordinance at the city level, of why they are choosing to evict and or non-renew a lease. There has to be a credible reason within Brooklyn Center if an eviction is going to be filed. And what that provides is just another layer of protection here, another layer where landlords, property managers have, there's one more thing that they have to prove in order to forcibly remove somebody from their home or attempt to. So I won't go into too much about that because I don't have all of the details and I'm not the expert on that. The person in the webinar speaking is definitely has a lot more experience and background on how that has played out there. But looking at these two policies and even like diving into a bit more of where Minneapolis is at, I think will provide really good guidelines for, or things to pull out and lessons learned and constructing your own proposals to your cities. Thank you.
Awesome. Okay, so to bring us home, I will hand it over to Eric from Homeline just to talk with us about the local and state level efforts that exist to pass pre-eviction notice policies, and also talk a little bit about why you would choose to continue to push forward at a local level when there is something in existence at the state level.
Thanks, Ian. Yeah, so I'll try to run through this real quick. Thanks everybody for being here. So yeah, it was asked in the chat a little bit ago about state legislation, and so I do want to just touch on that quick. Homeline has had this on our legislative agenda for over a decade. As was discussed earlier, Minnesota is well behind every other state, pretty much every other state, and on this issue. It's just a basic common sense policy that is working. It works well when it's in place. So there is a fairly strong chance that this bill could proceed at the state level, and that's a really important consideration. Most tenant landlord law is on a state level. There are some federal fair housing protections. There is subsidized housing law on a federal level. Most of the protections that we talk to tenants about on our hotline are on a state level. And as I mentioned earlier, local cities can enact stronger protections like rental licensing and these types of protections as well as others. And so it's still a good idea for cities, and I appreciate Marilyn commenting on how there's a interest in strengthening St. Louis Park. I think don't get down on yourself or on the advocacy that happened in St. Louis Park. I don't think Minneapolis or Brooklyn Center or the possibility at the state level would be happening if we didn't have that first example. And I do remember, the original draft was 14 days or maybe even longer. It just got sort of watered down in the political process. So it still is an important to be doing that advocacy on a local level, because it sets examples. It shows that that this is a needed protection that community members see as fundamental right for renters to maintain stability in their homes and protect the whole community. And it's really common sense for tenants and landlords to just be on the same page. So it still is important to push this on a local level, but at the same time, this year we have a good chance to get some state legislation passed on it. And as I mentioned, it is something that's been on our agenda for a long time. The governor's office has had pre-eviction notice on their agenda, on their priority list for a couple of years as well as this year. And so I will put in the chat some links to the specific bill, which is House File 319 or Senate File 429 are the bills that are proceeding. And they do, the bills as drafted right now have passed in previous sessions in the House. So they've been talked about quite a bit. They're not new ideas at all. And they do tackle some of the items that Marilyn brought up, some of the hurdles or gaps that maybe were missing from St. Louis Park. It is 14 days. It requires that a landlord would have to include, if they do proceed with an eviction, they have to include evidence that they provided the notice to the tenant. So that provides the tenant a defense to the eviction if the landlord did not provide it. The court is actually required to just dismiss the case if the landlord doesn't include evidence that they submitted that notice. So that helps just avoid having these needless evictions happening if the notice is not getting to tenants to try to prevent the eviction. You can look it up yourself if you want to look into more detail. But right now, what was the next thing I was going to talk about here? So on the state level, this has already passed the one committee on the House side. The House Housing Committee has passed this. It has at least probably one more stop in the House in the Civil Law and Judiciary Committee. And then in the Senate, it needs to be heard in probably both the Housing, Homelessness, Prevention of Homelessness Committee and also the Judiciary Committee in the Senate. So there still are opportunities to advocate on a state level for this. And I'll end with a couple action steps that you can take. But before I do that, just wanted to share one other bill that is somewhat related to this that I mentioned earlier, that may not progress this year, but is also a good idea, is a bill to prohibit evictions for proceeding when a tenant has a pending application for rental assistance. So that's very similar to this in that a pre-eviction notice would help try to prevent evictions from being filed. It would get tenants that information and the ability to apply for rental assistance before the case is filed. And then if we had this other protection, it would pause or prohibit evictions from proceeding if the tenant was waiting for rental assistance. And, in a perfect world, we'd have a rental assistance program that just worked and was fast, but we don't have that right now. So in order to prevent tenants from facing these evictions and get the overdue rent in the hands of landlords, these two policies kind of combined would really help do that. So the last thing I wanted to say is kind of the two kind of major action steps that you could help with on the state level would be right now asking leadership to prioritize these bills. And you could broadly ask for leadership in both the House and the Senate to pass tenant protections, specifically landlord-tenant changes that level the playing field. And if you want to mention the specific bill numbers, we've shared those with you, the pre-eviction notice bill being House File 319 and Senate File 429. On our legislative agenda page, which I'll throw in the chat, there's a couple other bills there that are also progressing and have gone through some of the stops. There's a lot of bills at the legislature this year that are proceeding, and so we want to really make sure that there's a focus on these items that are just such a core baseline protection that Minnesota is behind on. So those action steps would be to call leadership. So who's leadership in the House? That's the Speaker of the House, Melissa Hortman. That's her contact information. And then in the Senate, it's Majority Leader Carrie Dietzich, and that's her contact information. So those legislators, they are considered leadership in the House and the Senate. They work for all of us, even if you have your own state, well, you do have your own state legislator, of course, but it's a good idea to contact them and ask them to prioritize this. Separately, if you want to contact your legislator, and I know there's some folks that probably already have legislators signed onto this bill, folks that are in St. Louis Park, your former council member, Representative Kraft is on the bill, I think, but if you're not in a legislative district where your rep or your senator is not on this bill, you can always call them and ask them to join, to co-author the bills. And you can look up at that link how to find out what district you're in and who your legislator is. Yeah, I think that's maybe all I wanted to share. Other than, yeah, so while we're working on the state level, again, I want to reiterate that it still makes sense to advocate for stronger protections on a local level. There is a chance, last year there was a bill introduced at the Capitol that was somewhat similar to what Brooklyn Center passed in that it would provide just cause protections for tenants, which is Brooklyn Center is the only city in the state that has that. The chances of something like that happening at the state level are a little bit tougher jump than this pre-eviction notice, since we're so behind, Minnesota's so behind on that. But on a local level, it is working in Brooklyn Center, and so I think it's a good way to demonstrate to state legislators that Minnesota is behind. We need more stronger statewide protections that help tenants regardless of where they've chosen, or where maybe the only place they were able to find affordable, decent, safe, affordable housing. People should have these protections regardless of if they live in one city or the next. But in the meantime, if we don't have it on the state level, getting some of these protections in cities demonstrate to legislators that they can work, and that there are examples that can be translated to a state level. So I think I'm over time, so I'll be quiet and see if there's questions.
Yeah, thank you, Eric. So yeah, that's the end of what we had planned in terms of the formal program, but now we can use this time, this 10 minutes to answer any additional questions that popped up for you. I'm seeing Steve in the chat asking, does OZSI have city level eviction data for all cities in SHHC or the participating teams, or just across Hennepin County? And OZSI is saying, I think I would, but I would need some time to export and things. Okay. We have another question. Will the federal end of the pandemic declaration have any new implications? So we'll leave that juicy one out there. I see, Mike, you chimed in.
Yeah, I don't think so, is the short answer. There were some federal laws, both under President Trump and President Biden, that prohibited evictions during COVID, but those have all, ultimately the Supreme Court decided they weren't constitutional the way they were designed. So they are no longer in effect. And so I don't think that any new phase of federal legislation will have much of an impact on eviction prevention, at least as near as we can guess.
I want to pull this one up because it might have gotten a little bit buried. But from Tess, do the city policies or the state proposal say anything about whether / when the landlord can start the eviction process again? Or how would that work?
I'm sorry, Tess, do you mind speaking? I don't really follow the question. Do you mind kind of filling it in the blanks?
So, I mean, in the obvious example, I guess, would be if a landlord fails to give the tenant notice in one of these cities currently, and then the court dismisses the case, but the tenant still doesn't pay their rent, does the landlord have to wait before they can then like give notice to the tenant and sort of start the process over, or in other circumstances?
Yeah, so I think the landlord would have to file the case again, but they'd probably, if they didn't give the notice originally, they'd still need to give the notice. So if they're in Minneapolis, for instance, they'd have to give the 14-day notice after the case was dismissed by the court for doing it wrong. I assume that case would be dismissed, as the court calls it, with prejudice. That's the phrase, meaning you can't just restart that case. You'd have to go file a new one. That's my best guess on that. Yeah.
The state proposal as drafted right now would require, if the landlord doesn't attach the notice to the court filing, then the court is supposed to dismiss it without prejudice and expunge that court record. So it would allow the landlord to give a notice in the future, but that case gets expunged.
That's another good question. So why are our bills only asking for 14 days notice instead of 30? How did we come to that number?
Yeah, that's a good question. The there's a number of reasons for it. One strong reason is that it to a certain extent matches another protection, or not protection, another law that is one of the more commonly used laws in Minnesota tenant landlord law, and that is that if you're a tenant and there's something wrong with your unit, a repair issue, you need to notify your landlord and give them 14 days, let them know what's broken, and give them 14 days to repair it. And if they don't repair it, then you can go to court, file a rent escrow action. So it's sort of tying it to a similar timeline on the tenant side of things, if you're asking the landlord to fix something. And then other reasons are that in other states, there's much shorter ones. There's some states that are only 3 days. There's some that are longer. It was sort of a decision around, this is kind of somewhere in the middle. Preferably it would be tied to the timeline for rental assistance. So that's why I brought up that there is a separate bill. And it worked well last year when we had the eviction moratorium phase out. We had this temporary protection that prevented evictions from proceeding if there were pending applications. I'll put a link in the chat to that bill, because that's another one that is kind of in this realm.
I'm gonna go with Steve's question, and then Nancy, I'll let you come off mute to ask a question. Should we ask leadership to prioritize only the pre-eviction notice? Asking for tenant protection in general seems to dilute our message when contacting you.
Michael, do you want to take that?
I'm going to say it's your choice, but right now there's a huge effort to get more affordable housing funding, and that's an action alert that's targeted to leadership. And tenant protections aren't specifically being named as something that should be a priority in the action alert that is being sent out. And so that would intensify the need for them to take a look at tenant protections. If you want to mention this, specifically you're interested in pre-eviction notice, it's one of the game-changing items that we have at the legislature right now, and it would help to, say both things at the same time if you wanted to. But I would start with make a priority of tenant protections and then go into the pre-eviction notice.
So highlight generally and then get specific about it.
Exactly.
Nancy.
It kind of goes along with that. I was wondering if someone would be willing to write a script to that effect, so that we would really have the full information to contact our legislators. And I understand also, about the two people, Carrie Dietzig and Melissa Hortman, who are writing about this, but I am wondering whether there are other specific people on the committee that we should be contacting. So it's a two-pronged question. One of them is it possible for you to write us a script so that we could send an email or call their offices? And then the second part of it is, who else should we be contacting on those committees?
It is possible to write a script. It's really general information. We can do that. It's best if you actually do it more from a heartfelt or personalized perspective for it to matter. But if you want that, it's something that I could get to and get out tomorrow rather than right now. And then, are there other legislators? Yes, there are. But I'm going to ask if people have time. The two that we've given really are the priority. And then if you have time, you could move on to Representative Howard, who's the chair of the Housing Committee, and Senator Hort, who's the chair of the Housing and Homelessness Prevention Committee. And they get the chance to really sort of take the lead on what within the housing world will get prioritized. If they want to set priorities or have to, they can do that.
Y'all are asking some really great questions today. I appreciate it. From Tess, any objections? It's kind of a two-part. Any objections or concerns that have been brought up at the Capitol so far? I assume relating to all of these things that we've been discussing. And then also, are there any points of compromise that we should ask our lawmakers not to make?
I think mentioning a not is not helpful. Be affirmative in what you want right now is what I would say. And then I see, is there a question about, is there umbrella legislation? There's some talk about that happening, but it hasn't happened yet. And so that if you want to prioritize pre-eviction notice, that makes sure that if they are compromising on particular items between the houses, that pre-eviction notice would not be one of the things that they would compromise away.
I'll add to that really quickly that on our legislative agenda page, which I'm putting in the chat again, that just has our legislative agenda, which includes this and expungement and a number of other things. We are going to be updating that shortly to include some other tenant landlord bills. There's just a lot of them right now, and it's hard to know what's going to go forward and what isn't. But we will update it soon. We do expect all of those bills that are on that page right now. Most of them have started to proceed, and we think that they'll move. And then there was a question about yeah. Oh yeah, you answered that, Michael. Don't say anything in terms of how to compromise. Don't let it go any less than 14 days for sure.
We've got a couple more minutes here. Do we have any final questions? What are the stats on how much of an outlier Minnesota is on this again? And maybe that's something we can also include in that script we'll put together.
So that link I just put in the chat is has our legislative agenda, and it has, if you click on the bolded names, there's like PDF one-pagers that have background on each of the bills, and one of them has the info. We're one of 4 states. If you're a lawyer, you get into the details of what exactly counts as one of these, and that's why there's a question as to are we the only one? Are there 4? it's a little complicated, but most states have this.
Arnie.
You know, one of the things that's really important is to take advantage of all the systems that are now in place for us to be able to contact our legislators, state representatives, and state senators. Email, phones, their legislative assistants, and they want to hear from us. It's just amazing how responsive they are. I just take them to have them on speed dial, and they're always there to serve us. And I think just think that it's a maze and difficult to get to. It really isn't. The systems are all there for it. The structures are there, and all the emails and websites at the Capitol. So take advantage of it, and then let them get to know you by first name. That's my goal. Thank you.
Awesome. Thanks
I
for that.
love it.
Appreciate that.
Yeah.
And I'll
thank
pass
you,
it over to you.
Heidi. Yeah, absolutely. So yeah, I for the folks who registered via the link, I have your emails and I'll be sending up a follow-up. We can include a link to the recording itself. We can record some bullet points if folks want to reach out to their legislators that you can model a message after. And good ongoing conversations for how to move these at the state level and locally. If anybody did not register via the link, I'm going to drop my email in the chat. You can also just go on JCA's website and check in with me so that you are looped into any further correspondence on how to support this, or if you need further information, like Ozzy was talking about earlier in the presentation, to kind of back up pushing for this at a local level in your city, feel free to reach out to me and I'll be happy to make the connections. Yeah, one last thing I'll say before we go, as a good little JCA employee, I would love to plug our upcoming Freedom Seder this coming March. I'll drop a link in the chat for that as well if anybody wants to register. Going to be an amazing program. Lauren at JCA is working hard on it and would love to see some folks there so we can continue these justice conversations and guide JCA's work in the new year about, what policies we want to push for, what do we want to prioritize. Yeah, huge appreciation to all the speakers today. Everybody who showed out and asked questions, fantastic questions. I'm going to go ahead and hit the stop recording button.